Sunrise Daily, well, we're keeping our focus on that Electoral Act amendment. Already you might have heard that the court did give some describe it as a preservative judgment, order restraining the National Assembly from proceeding. Already we also know that the president rejected it and did not send to it, sending it back to the National Assembly. So that's what we're taking a look at this morning. And we have on my immediate right, Mr. Mekangige, Senior Advocate of Nigeria, and on my far right, Mr. Robert Emekwero, Legal Practitioner. Gentlemen, thank you for coming on this morning.
Thank you.
Let me start from you, Mr. Ngige. I mean, looking at this, many different perspectives, really. But when the court went ahead and said, well, they had to give this preservative order so that they don't destroy the rest, because if the National Assembly invokes their powers in Section 58 and proceeds getting that to third majority, then there'll be no need to come back to the court. Is this in order?
Well, you know, I stand the risk of being a contempt of court. Well, better than this for me to go into deciding whether it is right or not. But all I can say is that a court has the power to protect the proceeding before it. It's a settled principle of law that where a matter is before the court, the parties should not foist a fait accompli on the court. So in this particular case, from what I have read, the matter came before the court. The lawyer for National Assembly informed the court that they had just been served, maybe on Monday, 12th. And the matter came up, I think, on Wednesday. So under the Federal High Court rule, they have 7 days within which to react to the motion and notice. So she sought for an adjournment, and the other side were not opposing, but requested her to give an undertaking that the party should maintain status quo. Don't foist a fait accompli on the court until the time you are going to react. She said she will not give such undertaking. So, signaling that they are poised to foist a fait accompli. The judge has to protect the proceeding then by making that preservative order. But that does not mean that at the end of the day, that case or the other will be affirmed. It's just interim till next Tuesday, I think, until 20th. By that time, they would have reacted, and the motion will be argued on its merit. So that's the perspective I'm looking at it.
Well, Mr. Mekwere, there are those who argue that, yes, general principle of law, they have to protect the rest, but they also argue that in this particular case, there seems to be a big question. Do you agree that it can apply in this case as well, and they have to proceed?
Well, I think I will have to agree with Chief Emeka Ngige saying that the court really does have powers to preserve the subject matter of litigation that is before it, without regard to the merits or the demerits of that case. Because unless and until a case is ultimately decided one way or the other, the court needs to be the master of the situation so that none of the parties would have an advantage over the other by not keeping matters in status quo. You know, ordinarily, even without regard to the court making an order, once a matter is before the courts, both sides must just simply hold or sheath their swords.
Principle of what, let's spend this?
Yes, you know, something along those lines, because you mustn't take any step that will render the court incapable of reaching a decision. And that was foisting on the court a fait accompli, so that whatever happens, there is no effect to be given to that judgment. So that's really the principle behind it. So the court should be a master of that situation.
But what about those who now argue that this is dabbling into the affairs of the National Assembly, that the court cannot stop them because the law says this is their primary responsibility? How do you stop them from carrying out and making laws, which the Constitution set them out to do?
Well, that would not be a matter for the court to decide, because certainly the defendant, in this case the National Assembly, will have to come and give that as their response to the case. So that is really going to the merit of the case. So if they say, well, you cannot go into this issue of separation of power, that is what the court is going to decide, ultimately. And until the court has had the opportunity of so deciding, it should at least be in a position where it is in control of the subject matter of the proceedings. So that's basically what...
Do you think that with this development, this perceived rift between the executive and the National Assembly, is it in any way helping this situation, especially considering the timeline that they hope to have the budgets passed?
Well, I think that appears more to be a political issue, because the rift between the National Assembly and the executive. I think it's a bit strange to me, because the government in power, it's also the government controlling the National Assembly. So there ought to be some means of how they will resolve this thing without everything every time getting into this kind of rather difficult situation.
The issue of separation of powers here, because that's an argument that a lot of people are concerned about, where the executive, the judiciary, and the legislature seem to, right now with this court case, they're all like coming to one point of, like their heads are going to jam somewhere. But how would that play out when we talk about separation of powers and the electioneering process?
Ordinarily, how it should have played out is the president has withheld his assent. The National Assembly overrides if they muster a number. Then somebody now goes to court to challenge the constitutionality of that act
Of the National Assembly.
of the National Assembly. That's how it ought to be. I've never seen a situation where you go and stop the National Assembly midway from exercising its legislative power. It's very strange. But I have not read the originating process filed by the plaintiff in this case to know what is the course of action. I've just read the snippets from the newspapers, the relief being sought in the motion paper. So that is how the separation of power plays out. The executive have done his own by withholding. Legislature tries to muster.
Which is normal process.
Normal process. And then, like it happened in 2002, when they passed the Electoral Act of 2002. They waited for them, they passed the law, then they went to court. And in fact, the Court of Appeal said they would have nullified the entire Electoral Act, if not that it will affect the election that was already scheduled. So they now struck down some obnoxious sections in that law. That was how the Court of Appeal, Oguntade was in the lead panel that handled the situation. So that's how it should be. Then coming to what the question you asked him about why this conflict ought to be happening now. The reason I mentioned it in one of your programs, that APC, PDP, all the political parties, they have a provision in their constitution for National Caucus of the party. National Caucus comprised of the President, Vice President, Secretary to the Government, Senate President, Speaker of the House, that is if they are of the same party, National Chairman of the party, and the General Secretary, Leader of the party in the Senate and in the House of Reps. They are supposed to be meeting every week to discuss executive program and legislative program. That's where they harmonize. For instance, this issue of sequence of election, it is at that meeting, that caucus, that we discuss it. The president may express his reservations about the provision, and the members of the legislature will go back and see what they can do to accommodate. At the same time, if there are some certain things that the executive should do for them or ought to do, they will raise it. But we have seen that in this, our current democracy, National Caucus has become a rare occurrence.
So what does
they
that
don't
say,
meet.
What does that say of the Constitution?
And it started from Obasanjo's second term. Obasanjo was the one that killed the idea of National Caucus of the parties meeting.